Greetings to all. Welcome back to our YouTube channel. Myself Sanchita Sanand, a first year law student from Kolkata University and currently working as a legal intern at LEXIS and Company. So today I am here to talk about the Juvenile Justice Amendment Bill of 2021. The Juvenile Justice Amendment Bill of 2021, which seeks to amend the Juvenile Justice Act of 2015, was passed in Rajya Sabha on 28th of July 2021. The bill was tabled in Lok Sabha during the budget session in March this year, where it had received overwhelming support from both the ruling party as well as the opposition. So, what is the Juvenile Justice Act 2015, which is being amended through this new bill? The Act was introduced and passed in the Parliament in 2015 to replace the Juvenile Delinquency Law and the Juvenile Justice 2000. One of the main provisions of the new Act is allowing the trial of juveniles in conflict with law in the age group of 16 to 18 years as adults in cases where the crimes were to be determined. The nature of the crime and whether the juvenile should be tried as a minor or a child was to be determined by a juvenile justice board. This provision received impetus after the 2012 Delhi gang rape, in which one of the accused was just short of 18 years and was therefore tried as a juvenile. The second major provision is with regards to adoption, bringing more universally acceptable adoption law instead of the Hindu Adoptions and Maintenance Act of 1956 and Guardians of the Ward Act 1890, which was for Muslims, although the Act did not replace these laws. The Act streamlined adoption procedures for orphans, abandoned and surrendered children, and the existing Central Adoption Resource Authority has been given the status of a statutory body to enable it to perform its function more effectively. Now, why has the Juvenile Justice Bill of 2021 been brought by the government? Women and Child Development Minister Smriti Irani, who tabled the bill in Rajya Sabha, said the changes, which give increased powers and responsibilities to district magistrates, were being made to not only ensure speedy trials and increased protection of children at the district level with checks and balances in place, but to also speed up the adoption process in the country. According to the amendment, district magistrates, including additional district magistrates, can now issue adoption orders under Section 61 of the Juvenile Act in order to ensure speedy disposal of cases and enhance accountability. Adoption processes were currently under the purview of courts, and with an overwhelming backlog, each adoption case could take years to be passed. This change will ensure that more orphans in need of homes will be adopted faster. What powers will district magistrates now have under this new act? The district magistrates have been further empowered under the act to ensure its smooth implementation as well as garner synergized efforts in favor of children in distress conditions. This means that district magistrates and additional district magistrates will monitor the functioning of various agencies under this Juvenile Justice Act. In every district, this includes the child welfare committees, the juvenile justice boards, the district child protection units, and the special juvenile protection units. The amendment has been brought in based on a report filed by the NCPCR in 2018 to 2019, in which over 7,000 child care institutions were surveyed and found that 1.5% do not conform to rules and regulations of the Juvenile Justice Act, and 29% of them had major shortcomings in their management. So the NCPCR report also found that not a single child care institution in the country was found to be 100% compliant to the provisions of the Juvenile Justice Act. CCIs can be government run, government aided, privately run, or run through government, private or foreign funding. These institutions, while falling under the CWC and the state child protection units, had very little oversight and monitoring. Even to receive a license after an application was made, if the children's home were to not receive a reply from the government, Within 3 months' time, it would be deemed registered for a period of 6 months, even without government permission. The new amendment ensures that this can be no longer happen and that no new children's home can be opened without the sanction of the district magistrate. So now district magistrates are also responsible for ensuring that CCIs falling in their district are following all norms and procedures. During the NCPCR survey, for instance, CCIs with large funds, including foreign funding, had been found keeping children in unsanitary conditions in portable cabins. Since the survey, the WCD ministry shut down 500 illegal child welfare institutions that had not been registered under the Juvenile Justice Act. So this was all about the Juvenile Justice Amendment Bill of 2021. Thank you so much for devoting your time and listening to my video. If you really liked it, then please like, share and comment. And do subscribe to our YouTube channel Lexcliq for more upcoming such videos. Thank you so much and have a nice day.